Good afternoon or good evening, dear colleagues, friends. We're going to start without further delay, just to make sure that we have enough time for the discussion of this extremely important topic that was announced by us on these days. And actually, welcome to the webinar, one of the webinars in the series International Law Talks, which is organized by the Media Initiative for Human Rights, the organization that I represent, and also by Ukrainian Helsinki Human Rights Union with the support of the USAID Human Rights in Action program. And I think that it's hard to find any topic that would be so important and so actual as this one that we're going to discuss today. And I would just like to remind you about some context very briefly, because I think that the issue of environment and how do we protect the environment, including with the toolkit of the law, of the legislation in international law, is important and actual in both domestic and international context. Just on these days, we were witnessing how the UN issued another report, the sixth assessment report. It was issued by the Intergovernmental Panel on Climate Change, and it was quite an alarming document. It was discussed throughout all the international media very actively, and for a good reason, because it says that everything is really bad and we need to take actions right now. And also our domestic context, which is, of course, a part of the international one and all these climate change issues, but also it's a very special context related to the armed conflict, international armed conflict in Crimea and also in Donbass, and how this conflict affects the environment, the nature, and whether anyone can be prosecuted ever for that. So that is something that we're going to discuss today. And we're very pleased to be accompanied by guests that are very distinguished in terms of defining what actually the Ecocide is and about the international and Ukrainian context. But before introducing these guests to you, I would like just to make a small technical announcement that you can follow the Ukrainian interpretation of our conversation by using the interpretation button in the bottom of your screen. And for Ukrainian language, you have to choose the German option. And for English, you can choose English. So without the further delay, I would like to give the floor to Katarina Busol. She is going to introduce our guests and will kickstart the discussion.
Thank you very much, Maria, and thank you very much to our speakers and to all our guests who are joining us probably on their lunch break. We really appreciate your dedication to international law. Just a small comment that our first speaker, Ms. Syeda Rizvana Hassan, would have to leave a little bit earlier. So please make sure that you prepare your questions to Ms. Hassan in advance, and you can ask them here in the chat function, or you can also post them in the commentaries on Facebook or on YouTube, and we will read them out aloud. And now, without the further ado, I actually would like to give the floor to Ms. Hassan, who is a prominent Bangladeshi environmental lawyer. She's an enrolled lawyer with the Supreme Court of Bangladesh, and she is a recipient of numerous awards for her environmental strategic litigation. And I like that one of the awards says that it's given to people with pragmatic idealism, and it's very hope-giving to hear that it's the people with pragmatic idealism who are involved in the elaboration of the term ecocide, the new crime which might end up on the Rome Statute of the International Criminal Court. Ms. Hassan is the member of the expert panel which co-drafted the definition, and we are looking forward to hearing about her experience of the evolution of environmental justice in her native Bangladesh, and of course internationally as regards to ecocide. Ms. Hassan, the floor is yours.
Sorry, I lost you and I'm reconnected now. Do you hear me?
Yeah, we hear you well. Yes.
Just have a small presentation. I just thought for the audience to understand if I can really just to them. So I'm just do my screen sharing now. Do you see it all?
Yes, we can see it. Thank you.
Apologies that I just got lost. These technologies do not always. So telling you some of the issues that our organization is dealing with, which I would say are classic example of international and environmental justice. And these issues are issues that are happening because we are not being respectful to national laws. We are also not being respectful to international laws. And these issues actually have elements of criminality. Before I get into the issues, let me very briefly talk about some of the major environmental challenges we are facing here in Bangladesh. We remain actually the 8th most populated countries of the world, but much to my surprise, I found it yesterday that we have now become the 8th most populated country of the world. The capital of Bangladesh is the most densely populated capital of the world. We have a staggering population of 47,000 per square kilometer. Air pollution here in Bangladesh is often worst in the world. Our annual deforestation rate is just double the global standard. The global global average of deforestation is 1.3, and we have a deforestation rate of 2.6%. And in terms of environmental performance, the country ranks really low. So in 2019 and 2018, out of 180 countries, we ranked 179. But for last year, for some reason, we actually ranked 162 out of 180 countries. Climate change, which is all happening with knowledge of all our political leaders. If climate change is happening the way it is being feared, then 1/3 of Bangladesh will go underwater. The picture that you see on the left-hand side is the map of Bangladesh, the way we draw it now. But if climate change happens as it is happening as per IPCC, and there is a 1 meter sea level rise, then this part of Bangladesh, you see the red marked one, where we have 21 coastal districts, and these are coastal districts of a very populated small country. So these 21 districts will go underwater, which means that the next generation will have to redraw the map of Bangladesh. They'll be forced to redraw the map of Bangladesh, and all of it is happening. The climate is changing, sea level is rising with knowledge of all the political leaders we have around the world. This is a picture. In the previous picture, you see the river lines of Bangladesh. It is known as riverine Bangladesh. It is the largest riverine island of the world, but a very small country indeed. This is one of the major rivers of Bangladesh. You see the bridge over the river, but the entire river has dried up. And our rivers are mighty. So it's not that we only fish in the river, so we get water from the river, or we only boat in the river. They are also source of our culture. Many songs, many dramas, many novels have been written based on this particular river. We call it Padma. And we share most of our rivers with our neighboring country, India. Some of the rivers originate in Nepal, some in China. This is a river that we share with India, and due to arbitrary withdrawal of river water by the upper riparian country, which in this case is India, this is what has happened to the river. The entire riverbed has dried up, and now buses are plying on riverbed. So this is also happening in violation of the UN Convention on Non-Navigational Uses of International Watercourse. Sundarbans, the world's largest mangrove forest, is in Bangladesh. We shared this largest mangrove forest with India, and this is the home of the threatened Royal Bengal tiger. The government of Bangladesh and the government of India have decided to develop a coal-based power plant within 14 kilometers of this forest, which is also a World Heritage Site. So it is a protected area under the national law. It is also a protected area under the UNESCO law. UNESCO has objected, local people have definitely objected, and the guy has written on his chest that please scrap this agreement. And the plant is called Rampal coal-based power plant. Rampal is the area where it's being built. And now you can see the forest from this land, and the entire landscape has been cleared, which used to have wetlands and sparses of mangrove forest here and there, because it is only within 14 kilometers of the world's largest mangrove forest. It has all been cleared, and the Rampal coal-based power plant, the construction has almost completed, and it's expected that the power plant will come into end of last year, if not this year. This is something that has happened this year. This is a coal-based power plant being constructed in another coastal area with money coming from Chinese banks. And when the local people protested in 2016, they opened a fire and 4 people died. Then subsequently 1 more people died. And off late in April this year, 7 workers eventually were killed because they're, pressing demands for payment of their facility and some other basic rights. This is again picture of another protest by the indigenous people who hail from the hill districts of Bangladesh. And the Marriott Hotel, the International Marriott Hotel, is planning to have a hotel constructed in an area that is inhabited by these people, or the land of which is used by these indigenous people. And unfortunately, the Bangladesh army is a party to it. So here you see the indigenous people protesting against this project, which is a joint venture of Bangladesh army and Marriott. This is the infamous case of shipbreaking, where all the Western countries, including US, UA, they send their vessels. And the entire ship dismantling takes place on the open beach without any sorts of protection, containment facilities whatsoever, and the ships are all broken manually. In the process, the laborers inhale deadly elements like asbestos, and we are now dealing with at least 40 laborers who we suspect to have developed asbestosis, which is a form of lung cancer. And we have Basel Convention that clearly bans this sort of waste dumping by the developed countries on the territory of the developing countries. But the provisions of the Basel Convention are being rigorously violated because the Western countries want to find a place where they can actually dump their waste on. Our rivers have turned into cesspools. And then we have these additional elements of neoliberalism, colonialism, and criminalization. People's right to participate in decision-making, their right to avail justice, to get redress, to get environmental information are being denied in different tactics. Privacy and communication being denied. So whatever I'm saying, whatever is there in the Facebook that comes from my mouth is being monitored. Whatever I'm saying on my personal devices are probably being recorded and monitored, and the state has the mechanism to always use it against me. So they access my private data and my private communication, whereas I don't necessarily have access to the official information that are meant to be public. And the narrative of development is very much GDP centric, and it's not at all sensitive to protection and conservation of nature and ecosystem. The environmental human rights defenders are facing arrests, assaults, threats, propaganda, and all these are very systematic. These are not isolated events. These are being done very systematically on different disguises by different agencies, by different players. We do have Foreign Donation Regulation Act, the Digital Security Act, Information and Communication Technology Act, and Special Powers Act. All these acts have given weapons, have empowered the government to take actions against anyone who opposes or who may oppose the development narratives of the government, where elements of corruption are clearly present. So I was involved in this definition development work that was done by 12 lawyers. So we believe, being an activist from Bangladesh, I strongly believe that the crime that we are regularly committing against environment, against the environmental human rights defenders, need international recognition and need legal recognition so that the environmental human rights defenders are protected, nature is protected, and we actually manage to redress the injustices that are happening because of a partnership between national governments and international governments, national players and international players. So we demanded that the Rome Statute be amended and the fifth crime be inserted, and the fifth crime should be called ecocide. We proposed changes in the preamble, and in the preamble we pressed that there should be a recognition at the global level that the environment is being daily threatened. Severe destruction and deterioration is taking place, and that is damaging not only the human system but also the natural system, and in many respects these damages are irreversible. And we have said that the ecocide should be defined as unlawful and wanton acts. So it should not only be unlawful, reckless acts that are committed with knowledge, for example, climate change, and that has the potential of causing substantial likelihood of severe and either widespread or long-term damage to environment should be given recognition as ecocide. Very encouragingly, there has been a judgment by the High Court of Bangladesh, who was dealing with a case of land grabbing, grabbing of
Dear Rizwana, I think you might have frozen. Perhaps you could turn off the video to make the connection a bit better.
Katarina, maybe we can proceed with our second speaker, and when
yeah, I think we'll probably, yeah, she's probably reloading her Zoom. I'm sorry. Let's wait perhaps for a minute, because I'm sure she'll just log back. We'll just probably ask her to speak without the video. If she doesn't go back in half a minute, then we'll proceed with Mr. Andrusevich, okay?
in the meantime, just not to waste the time, maybe it's we can also say that we're accompanied by our colleagues from Truth Hounds. They have prepared the report on the environmental damage brought by the armed conflict in eastern Ukraine. And Roman Avramenko, who is here with us, he is going to share with us some results of the research after Andriy is going to speak. Now, I think,
okay.
Okay, Katarina, can you please introduce Andriy so that we don't...
Oh, I think Rizwana is back. Rizwana, can you hear us?
I can. Actually, I'm getting disconnected. I don't know why. It's something that... But I'll
sorry,
keep on
perhaps
connecting back.
Might it be better if you speak without the video, because we can hear you well.
Okay.
Yeah, probably it's better to switch off the video.
Yeah.
Thank you very much. You're also muted now. Rizwana, can you unmute yourself, please?
Yes. Do you hear me now?
Yes, we do. Thank you.
Okay. Really sorry about this. I don't know why it's happening.
It's fine. We were listening diligently with great interest about the changes to the preamble that you proposed, and then to the further articles within the Rome Statute.
I think I'm done with my presentation. You gave me 10 minutes only. So then there will be questions and I'll be answering those.
Okay, thank you very much. And I think Maria had the first question.
Yes, thank you. Actually, I have plenty of questions, and I would like to follow up on the definition that you've presented. Also, I mean, I've monitored some of the media materials regarding this whole issue with the definition of the ecocide, and that is something that you can see all over the place. And my question is, so you have like a really distinguished panel of legal experts working upon this definition. And while you were working upon this definition, I'm wondering what difficulties have you met, have you faced? I mean, what risks or what challenges do you see in defining the ecocide? Because it's not only about the definition, it's about how you see the inclusion of this whole idea of prosecution and criminalizing the ecocide in this whole international system, international law system. And whether there's, from your opinion, what's the mechanism of the inclusion of ecocide to the Rome Statute, how this can affect and change the behavior, which is probably the ultimate goal, is to change the behavior so that these crimes are not being committed. And also, what is actually going to happen next? Do you see the readiness of the countries members to the ICC to adopt this amendment? And whether you see any opposition to this idea and from which countries? And do you see any problems with such a very important and influential countries as the US being excluded from the ICC system? So if they do not accept this idea, whether it can be supported and most importantly enforced internationally?
Okay. Thank you. So I would like to give the answer not as an academic lawyer, but as an activist practicing lawyer. So you see, even in today's world, when we all know what we are doing to our climate system and what this can offer us in return, how the entire human civilization, global civilization, has been put to risk because of our inaction in handling or in tackling climate change, and because of our reluctance in changing the development paradigm. I won't say that there will be an automatic endorsement of the idea to include ecocide as the fifth crime. There will definitely be opposition, but at the same time, there will be support. There are European countries who are already supporting this proposal. There are green parties in Europe who are already supporting this proposal. There are simultaneous movements taking place in the global arena to recognize certain acts and omissions with regard to environment as crime. So there will be both flows together, absolute support, absolute opposition. But if our argument is fact-based, if our argument is supported with documents, I think we'll be able to make a very strong case. So some member countries can give a proposal. In fact, this was discussed in the ICC. It is not something that would come to them as a total surprise, but there was not enough push behind the proposal when it was first raised. So if we can manage to kind of get support of some diplomatically powerful countries in favor of our proposal and give it a strong push, it will definitely form an agenda to be discussed by the ICC state countries. But then, as you have pointed out, that US is not a member of ICC, but US remains a major polluter in many respects. So in ICC, you will actually be taking cases against individuals who are doing the crimes. One challenge would remain, if you think about the climate system, that you can't be taking a case because criminal law is not retrospective. However, I don't fear that the offenses that are being committed now will not be committed tomorrow, or will all stop with the adoption of the definition ecocide by the ICC. That is not going to happen. Because we see how war crimes are still happening in this world, despite ICC operating there, despite we having clear laws against war crimes. So I would say that the reason why I involved myself with the whole process, not only because I was approached, because I see how our natural resources are being plundered by multinational corporations, and how pathetically my national legal regime is failing to give me any protection. I also see that how I cannot approach respective state governments when their corporations are in violation of human rights and environmental rights in my country. So I was in search of an international platform that I think would be able to give me some sort of relief. I'm not saying that it will solve all of my problems tomorrow, because if you don't have political commitment, that will be hard to achieve. This proposal in one way is also to gain political commitment, more political commitment for the major international crimes that are happening worldwide. And with that political commitment, with that political support, you will be able to push this proposal in the ICC with some success. So, of course, there will be opposition, but I also am optimistic that I will get good support in favor of our proposal also. It will actually shake the political consciousness. And it is not only today's generation who are leading the ICC. Tomorrow's generation will be tasked with more onerous job to protect the climate system. And we see how younger people like Greta Thunberg and others are creating the movement worldwide. So it has become a global movement. And the process that we are starting today may not be in 2 years' time, but in 10 years' time, that will definitely see some success.
Thank you so much. Since Rizvana is going to, will have to switch off a little bit earlier, I would like also to ask you one more question. Sorry for that, but it's really important because, I mean, about Ukrainian context, I'm not sure how familiar you are with that, but just maybe you can provide us with some general recommendations. In the current circumstances, when we don't have ecocide included in the Rome Statute, but still there are like there's some legal kind of system, infrastructure, international law system that can provide some possibilities in order at least to monitor and maybe to document the damage done to the environment. So what can be your recommendations to for instance, the Ukrainian government, but also to Ukrainian civil society? What should be the priorities for us in order to bring in further to responsibility those people who are committing some environmental damage in the context precisely of the armed conflict in the territory of our country? So what are essential tools to be used here, just not to waste the time and to use this moment and to document it so that potentially those committing these crimes can be brought to responsibility, whether at the ICC or in any other institutions?
I think the first responsibility actually lies with the national governments. The idea behind Ecocide and getting it included in the Rome Statute is actually to give individuals some sort of relief when individuals are failing to avail relief or adequate relief at the national level. I think it's very, 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 very important that the national governments update their own national environmental laws. They include provisions to punish adequately the perpetrators. They seal all the gaps in their national laws that allow multinational companies to come and exploit their natural resources without adopting adequate safety measures. I think it is also important for national governments to stop damaging their own environment. When I showed you the picture of the river in Bangladesh that has dried up due to unilateral withdrawal of water by India, I can show you plenty of such examples where rivers have actually dried up due to unplanned intervention by the national agencies here in Bangladesh in the name of flood control, in the name of irrigation. That we must stop. So the national government should redefine their environmental agenda and should redefine their development agenda and should not be GDP centric, like gross domestic product centric. It should be more like gross happiness index type assessment of your development, the way Bhutan is doing it. So the first onus is on the national governments to update their national laws to seal all opportunities for exploitation and doing permanent damage to nature, and to have adequate provision for punishment. And then I won't say it's only for the national government, because in most cases, national governments are also party to all these unfair things that are happening in the name of development. It's also their leadership failure that lead to armed conflicts. So I would say that citizens who are being affected should be working with national and international agencies to start collecting documents and evidence of violations, of atrocities, of crimes that are being committed against the nature. And I don't think that in today's world, with the degree of connectivity that we have, that would be very difficult. You have reached me out from Ukraine. I live in Bangladesh. I was totally surprised. So you see, the connectivity is very, 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 very important. And from the very beginning, it's not only from an activist viewpoint that you should be collecting the documents, you should be collecting those from a legal viewpoint as well. And whatever you collect should have a very sound economic, social, and environmental analysis. So collection is important, connectivity is important, fixing your own system is important.
Katarina?
Rizvana, thank you very much. And actually, thank you for pointing out this connectivity between Ukraine and Bangladesh. It was so important for me for this webinar and just the concept that Maria and I nourished for this series to show the interconnectivity of the majority of these international legal issues that we are facing, and of course in the realm of the environment. So it's just our additional thanks to you that you agreed to participate, that we could show this holisticity of these issues. And just again, because you leave earlier, let us please ask another question which we got from the audience for you, from Ms. Angayova, who's asking, have you gathered, I presume for the expert group working on the Ecocide definition, have you gathered any statistical data regarding the quantity, the number of cases of alleged ecocide per year, whether some of them were registered or transferred to the court, or whether some persons were convicted? Because some jurisdictions like Ukrainian, for instance, they do have ecocide in their domestic legislation. So have you done any like statistical work on such domestic proceedings?
Yeah. There have been a parallel process that was going on. While the lawyers were busy drafting the definition, there was a parallel process going on that actually gathered instances from national and international legal documents about how ecosystem has been defined, or what are the different ideas around this whole notion. So yes, based on what was collected through that parallel process, there was a summary that was presented to the panel, and then the panel worked on it. The panel considered those. And we all the panel lawyers got the opportunity to share our own instances where we think ecocide has been committed. We all shared examples that we think can be termed as ecocide and are examples that require an international system to ensure justice. So in addition to the parallel system that was talking to people, getting their ideas about how it should be defined, and doing a legal research about existence of such definition in other countries and in international laws, we were also sharing our own experience of examples that we think can conveniently be defined as ecocides.
And can you share a couple of the examples which you think now amount or have recently amounted to ecocide?
See, the whole issue of when we were drafting this, the direction that came against Shell to compensate the Nigerians, that was discussed. The other case was the Bangladesh issue of shipbreaking that was discussed. Somebody brought in the issue of climate change. Somebody brought in the issue of oil spill. I mean, on some of it we agreed, on some of it we did not agree, because we did not think that those had the elements of internationality, if I may say so. Some were severe, but were not really very long term. Some were severe, but not really widespread. So we wanted to come up with examples that would meet at least two of the threshold that we have included in the definition.
Thank you very much for providing the examples. And we will now turn to our second speaker, who's Mr. Andriy Andrusevich, who's a famous environmental lawyer in Ukraine, and he's a senior policy expert within the Society and Environment NGO. Andriy specializes in particular in the implementation of the Convention on Environmental Impact Assessment in Transboundary Context and of the Aarhus Convention. And he's also a member of the International Council of Environmental Law and of the International Union for Conservation of Nature. Andriy will pay the particular attention in his presentation into the alleged environmental impact of the Russia-Ukraine armed conflict. Andriy, the floor is yours.
Thank you, Katarina. Indeed, I plan to focus more on the context, since this discussion is about the Ecocide in the context of the armed conflict that we have. So my 10 minutes I will spend these next 10 minutes trying to bring the Ecocide and other environmental crimes into that context. I mean, first, of course, I mean, I agree with Rizvana that the key point is the effective environmental protection system in the country. You can't claim international, I mean, support or crimes if within your own country, you as the government do not have an effective environmental policy. So building an effective environmental protection system is a must. Generally in Ukraine, the environmental policy, in my view, remains, I would say, at the back door of the national agenda. That means that the economic priorities have, I mean, much more importance and much more discussed, and the government spends most time on these issues. And secondly, of course, the issue of the armed conflict and the temporary occupied territories is also attracting a lot of political attention. And these are the two major, I would say, focus areas. So the environmental policy stands very low in the to-do list, in my view, of the government as such. Having said that, the Ukraine is making even within this low, I would say, room in terms of the priority of the work of the government. Ukraine is making big efforts in the last years to improve its environmental policy. I mean, especially in areas like water protection, floods, environmental impact assessment, and strategic environmental assessment. All of that is being with the overall aim of aligning our policy and legislation with the EU acquis. The government is not working in isolation. It actually, pays attention to what the people are willing the government to do, what are the priorities of the citizens. We have commissioned a public poll a few years ago, all Ukraine public poll, where we tried to understand what citizens think about environmental policy, environmental problems. And we were, I would say, rather surprised to see that Ukraine, for example, and the EU, we used a similar methodology, share the same environmental values. Just one example, that the environmental protection as such is personally important for over 90% of the citizens of Ukraine. It's a very high number. At the same time, economic, for example, factors have a priority both in the EU and in the Ukraine over the environmental ones, despite the obvious differences in the economic development between Ukraine and the EU member states. Where we are lagging behind is the practice. So we share the values. However, the citizens show much less practical commitment to do even simple things like, I don't know, waste sorting or something in Ukraine. And that's where I think we all can work more. I mean, we, the government, the civil society, the international community. And a last point regarding the general policy background, before I go into the Ecocide issue, is the use. As we discussed previously with Katerina, there is a myth that use is more progressive, that use is more pro-environmental. Well, maybe in some countries, but not in Ukraine. Our poll reveals that use does not have a high environmental priorities compared to other age categories. And in some even cases, they're even less environmentally, I would say, aware than the older populations. One good thing about the youth is that they show a very high confidence to non-governmental organizations, environmental organizations, which is a very good sign in my view. It means that there is something to build on for the future. Now, about the Ecocide, the national criminal law, we all know it, has a definition or has an article on ecocide as a crime. It generally, I must say, follows a old post-Soviet approach, which is almost literally this article represented in quite some countries of the region, in the criminal codes of the other countries of the region. I'm not aware of any ever court decisions, judgments on this article, bringing people responsible for ecocide. I also have never heard any investigations reported in the context of the armed conflict. What I've heard recently in Ukraine, that the security service of Ukraine is abusing its investigating powers and claiming there are ecocides. They're investigating a possible alleged ecocide crimes in the context of forestry, for example. However, again, I'm not aware of any investigations in relations to the armed conflict or any actual, final court judgments on that in Ukraine. In particular, I must say that we don't need to wait for the International Criminal Code statute to be amended, since we already have this crime in the national legislation. And as Rizvana said, the criminal law is not retroactive. So even if or even when the statute, the Rome statute, is amended, it doesn't mean that the crimes committed as environmental crimes will be subject. They will not be subject to investigation by the ICC. However, there are crimes already committed, like widely reported case of the Uncom mine, which we all know has a high risk of the radioactive pollution. However, I mean, there was no, at least I have not heard any discussion about the investigation, I mean, a formal investigation about this case as a criminal case under the Article 241, the Ecocide crime of the Criminal Code of Ukraine. Now, about the amendment of the Rome Statute as such, I think a serious discussion is needed in Ukraine if the proposal is going, is going to be put forward more formally, I would say, by other states. The way the international treaties are amended, it's not just a legal work, it's both political and legal. At the end, it becomes a legal, let's say, text, an article, a provision. However, in the process of developing the amendment, of working on it with other parties, of having the parties go through the ratification procedure of that amendment, I mean, it's a political process, and it has impact on the legal issues, on the legal meaning, on the legal consequences within that definition, or whatever you call that provision on the Ecocide, proposed Ecocide for the Rome Statute. In this context, if some wants to build a support by Ukraine, there needs to be, and by policymakers in Ukraine, there needs to be a serious discussion, because clearly Ukraine will consider other, let's say, not options, but other implications. I mean, the law ideally doesn't work one way. Of course, in Ukraine, we think about the conflict as bringing Russia and its officials to justice. But ideally, the law doesn't work like that. Ideally, the law is not about winners bringing the losers to justice. Ideally, the law is equally treating everyone. And we all heard these allegations recently by the Russian officials about the situation with water supply in Crimea, and specifically they were claiming the Ecocide crime. Now, in general, I think the Ecocide in the context of the armed conflict gives answer to just one question. I mean, bringing the responsible persons to justice. However, the Ecocide as such leaves behind many other, I would say more even important issues, which are restoring the environment, improving the situation. It's not enough just to bring people responsible or liable to the court. Now, there is no, Ecocide doesn't give answer to the damages. To, like, I mean, one example is Iraqi-Kuwait war, where the Iraq, there was a special decision by the Security Council, and Iraq had to pay for all of the damages that, the intervention, I mean, the military intervention into Kuwait has cost, including the environmental ones. I mean, we are talking about hundreds of millions of US dollars, as recommended by the special commission. In any way, the Ecocide may work both ways, as I just said, not just towards the Russian army. And if we are thinking about not Crimea, but the armed conflict on the east, clearly, I mean, it may affect the Ukrainian army as such. However, I have never heard and never seen any discussion in Ukraine about the investigations or any possible even allegations about the Ecocide, Ecocide allegations or other environmental related allegations put regarding the actions by the Ukrainian army. So if you want to build this kind of support for Ecocide, I mean, there needs to be, I think, a profound discussion within the Ukraine. Now, about the two more points, about the actual environmental consequences of the armed conflict, there were quite some efforts made by the NGOs, by civil society. and by some international actors trying to assess what are the environmental consequences. The government of Ukraine is also trying to do some, let's say, monitoring. And the OSCE in particular report, there was a special report, so it's called Environmental Assessment and Recovery Priorities for the Eastern Ukraine, issued 4 years ago. It has identified several key risks that or I would say categories of environmental risks and damages that the armed conflict brought, which is a direct pollution during and after the actual military actions, and then the industrial risks, then the operational disruptions and flooding of mines, the water supply, the impact on land resources and ecosystems, and a general decrease in environmental activities. I mean, no efforts made to protect the environment as such within the conflict area. I may only add to that list by OSCE that the occupation of the Crimea brought systemic challenges to the environmental situation there, but that needs to be again considered separately. One of the I would say successes that I would, let's say, mention regarding the national and international efforts, both governmental and non-governmental, to tackle the environmental consequences or environmental dimension of the armed conflict, is that the volume of information on environmental issues in the conflict area has rapidly increased. A lot of data is gathered, though, I mean, regarding the Crimea, the access to the data is limited. The issue is, one of the difficulties is access, of course, to the territories, and the uncertainties and differences in the interpretation of the data that the Ukrainians or international actors are gathering within the conflict or largely outside the conflict area. And I think in this context, the OSCE and some other UN institutions, OSCE and UN institutions, have contributed to, I mean, these efforts to trying to gather and systemize the information, including some governments, by the way, like Canada, and as well as the NGOs who've been doing, I would say, an interesting and a good job on that. And my last point is that, you know, future action, understanding future action is the key to properly plan specific steps in environmental area. And I would suggest splitting, let's say, all of this work into 3 strategic dimensions. One is that, of course, Russia as a state and its officials must be liable for all the environmental damages. And therefore, the relevant information that's being gathered or will be gathered shall serve that purpose. And the way you gather, systemize that information is different if it would serve other purposes. So one, depending on the purpose, why you gather that information, the way you do it, the types of information you gather, the way you systemize it will be different. So one direction, I think, is, you know, thinking strategically and gathering information which will help to bring the Russia as a state and its official to liability. The second possible direction is the occupation efforts, such as the Crimean platform, which is going to be launched in a few days, which shall include environmental dimension, and it does include now. The difference is that if the overall objective of the Crimean platform is deoccupation, then the way you present, the way you gather, the kind of information you seek, I mean environmental information, again, must be tailored, should be made specific to that specific purpose. So it's not the same. You can't have a multi-purpose process of gathering environmental data, information, documents, etc. It must serve a specific, I would say, political and possible legal procedures that you expect or you are pursuing right now. And very last, third point, I think and it brings us back to the general environmental policy context. I am sure that what we should do now, we should develop a green reconstruction concept for the deoccupied territory. So when they are deoccupied, there needs to be no build back as you approach. We cannot just build back what was there. We need to have a plan, a big plan. How do we reconstruct, rebuild those territories in a green and sustainable way? And that requires, a lot of work. It's not a 1 day, 1 month, or I don't know, half a year process. It needs to be started, and there, maybe in 2 or 3 years, there will be a reliable, comprehensive plan how to rebuild the deoccupied territories in a green way. I'm ready to contribute and answer any questions if there are any. Thank you.
Thank you, Andriy, for this really comprehensive presentation. Now, I have to say that we have plenty of interesting questions and comments from our audience, and I'm really thankful for that. For instance, our colleague Anne Hayeva from World Wildlife Fund in Ukraine, she writes that in Ukraine, only 20 cases within 6 years were registered, and it's a question on how to show the importance and large-scale seriousness of such type of crime to decision makers. And also she says that her organization, jointly with 10 European partners, are working on the issue of wildlife crimes within the framework of the SWIPE project. We're not so much probably informed on that activities, but that's all very interesting and great, actually. So now just to say that at least preliminary, we had some registered colleagues, guests from the law enforcement system of Ukraine, precisely from the prosecutor's office of Crimea, and maybe they would like, we will just have to, I think, provide them the possibility maybe to answer to some of those statements that were made, for instance, by Andriy, regarding whether there's any investigations or any attempts to investigate the probably from some potential damage made by the Ukrainian side either. So maybe it's the job not of the prosecutor's office of Crimea, but rather the war crime unit, which is established within the Office of General Prosecutor. Colleagues, if you're here, please let us know so that we can provide you the possibility to comment or answer those questions. And I have one additional question to Andriy, actually, which comes from prosecutor's office, and since we know that they're they have registered indeed some of the cases regarding the ecological damage in Crimea made by the Russian Federation. So, and now they are trying to investigate. This is really a very specific question, and it's not the appropriate time and place to go very deep into details, but maybe, Andriy, you can comment just generally on that, or to provide like the general understanding where where Ukrainian law enforcement have to search for that expertise. So they're wondering whether there are any methods of determining the amount of damage to the environment within the criminal proceedings, criminal investigations, and who can actually provide this sort of expertise for the Ukrainian law enforcement. And presumably this expertise should be done at the proper level, so it can be potentially provided to some international institutions or to ICC maybe. As far as I know, there were no kind of claims that about that sort of crimes or that sort of cases within those submissions to the ICC that have been done so far by the prosecutor's office as well as NGOs. So, Andriy, can you comment briefly on that, please?
I think the prosecutor's office is doing its job well. The issue is that that's exactly what I was trying to say at the end. You can't just gather information because you know, and then you can use it for whatever purpose you want. If they have a criminal investigation, they need to gather evidences in the proper way. The way they gather, the way they document the evidences, including the whatever scientific assessments are or expert assessments are, must be acceptable to the court. And of course, to do that without physical access to the territory where you claim the environmental damage has occurred is very difficult, if possible. I would say, if even possible. If we look at the criminal investigation as a law enforcement procedure and not as a political process, then they are bound, I mean, the prosecutor's office are bound by very specific legal requirements how to present such cases. And that's exactly, I mean, one of the ways, I mean, which could have helped, I would say it's even past perfect, if there was a previous experience on that, but we have no previous experience on that, and therefore there is nothing to, I would say, on my side to advise who can do this kind of expert assessments for them, including on the damages. There is international practice. For example, as I mentioned, the special commission working on the Iraqi Kuwait conflict damages, I would say, estimation of the damages. So there is plenty of information available because it's an open work, which has completed already, I mean, many years ago. But the methodology they use to assess, because the governments, various countries, were claiming the environmental damages from Iraq, and then the commission, the UN Commission, was assessing those, whether the claims are substantiated, whether the damages were assessed in the proper way, and then made their own recommendations on what they think the amounts payable are by Iraq for the environmental damages of the military intervention. So maybe that process also could be useful, I would say. But again, in general, I mean, we need to distinguish these kind of general data gathering, information gathering, from gathering evidences within a specific criminal investigation, where everyone is bound. I mean, sorry for taking more time, but I would say most environmental cases in Ukraine, not crimes, I mean, brought by the environmental inspectorate, are, never end up in paying damages in the courts, because the way the information is gathered, the way the evidences are presented is, found by the courts to be wrong, because they use the wrong equipment, for example, not a certified equipment, to measure the air pollution or water pollution, or they do not use a proper procedure to gather samples. So, I mean, it all becomes very specific. Tiny details play an important role in criminal investigations. So clearly, I think the prosecutors and Crimean prosecutor's office are doing a good job, but they have very limited possibilities to properly follow the procedure as such, in my view.
Thank you.
Thank you very much, Andrei. And we finally also get to our distinguished third speaker. So Roman Avramenko represents Truth Hounds, a renowned NGO that does a very hands-on work. They are there basically on the ground, communicating with people, documenting evidence of different alleged international crimes perpetrated in Eastern Ukraine. And here today, Roman will present their findings regarding the environmental impact and the alleged environmental violations which were perpetrated in Eastern Ukraine in the context of the Russia-Ukraine armed conflict. And again, thanks to Anna Gayova, one of our listeners, members of the audience today, she provided some update as regards the statistics from the Office of the Prosecutor General concerning the cases, and you can see the dynamics, how the criminal proceedings actually really reached the courts and whether any of them ended up in a conviction. You can look for the more details in the chat function. And now we turn to Roman to hear more about their report. And just the final thing, many of the reports that Truth Hounds draft, they go as the ICC communication. So it's a very solid, not just factual information, it's a very solid analytical material, and we look forward to hearing you. Thanks, Roman.
Thank you very much, Katerina, for your kind presentation and very much detailed on us, on our organization. And hello, everyone. I will hold my presentation in Ukrainian, if you don't mind. So please switch your buttons on English if you need a translation. So, добрий день, я Роман Авраменко, я працюю в організації Truth House. Дуже радий бути тут серед людей і організацій, які займаються питанням довкілля. Одразу скажу, що наша організація не екологічна, ми не профільна організація, яка займається довкіллям. Проте ми документатори грубих порушень міжнародного гуманітарного права, яке регулює правила та звичаї ведення війни, захищаючи цивільне населення та об'єкти, які не беруть участь або не вносять ефективного вкладу в військові дії. Тому з одного боку і з іншого боку захист довкілля включено як мінімум в 4 різних документи або зводу правил, які якраз і належать до міжнародного гуманітарного права. В першу чергу це принцип розрізнення, який закріплений, який має звичаєву природу і який говорить, що потрібно розрізняти військові цілі від невійськових цілей, відповідно невійськові не робити об'єктами атаки. Так само захист довкілля під час збройного конфлікту закріплено в додатковому протоколі 1 до Женевських конвенцій. Третє – це згадана вже сьогодні не раз конвенція НМОД, яка забороняє будь-якій країні в рамках збройного конфлікту вчиняти дії, які би несли широку або довгострокову, або серйозну шкоду довкіллю. І четвертий документ – це Римський статут. Стаття 8 так само говорить цілком конкретно про те, що комбатанти, плануючи та здійснюючи атаку, повинні утриматися від дій, які би могли нанести, але одночасно широку, довгострокову і серйозну шкоду довкіллю. І ми присвятили цьому звіту, який я сьогодні презентую, він називається «Довкілля Донбасу або невидимий фронт». Він є на обох мовних версіях, в українській і в англійській. В електронному вигляді можна знайти в нас на сайті. Там тільки треба пофіксити англомовну версію зараз звіту, проте обидві мовні версії знаходяться на нашому сайті truthhouse.org. Отже, цей звіт є результатом 3-тижневих польових місій в зону збройного конфлікту на Донбасі. Я сам і мої колеги їздили збирати на місцях ознаки воєнних злочинів. Одразу забігаючи наперед, скажу, що з усього великого переліку насправді фактів погіршення довкілля, яке прямо пов'язане з конфліктом, лише 3 з них нашими спеціалістами можна було б віднести до воєнних злочинів, якщо орієнтуватися на статтю 8 Римського статуту. Про це я скажу трошки пізніше. Отже, 3 тижні їздили, збирали інформацію, проводили багато зустрічей, інтерв'ю в тому числі людьми, які працюють на підприємствах, зосереджувались на документуванні шкоди, яку війна прямо або посередковано наносить шахтам, водам на Донбасі, ґрунтам і об'єктам водопостачання, водовідведення, так само заповідним територіям, заказникам, заповідним зонам, об'єктам інфраструктури і підприємствам. Все це викладено в нашому звіті на 50 сторінок, тому я не буду тут все презентувати, тому що точно переберу свій ліміт в 10 хвилин. Скажу лише, що доволі значні негативні зміни ми побачили і відзначили під час документування. Наприклад, якщо говорити про шахти, то через їх закриття в першу чергу керівниками непідконтрольних територій там припиняється відкачування шахтних вод, шахтні води виходять на поверхню і вже забруднюють ґрунтові і поверхневі води, річки. Наприклад, ми брали приклад води біля шахти центральної в місті Торецьк, і хімічний аналіз показав, що рівень хлоридів перевищено майже вдвічі, 435 мг на кубічний дециметр при нормі 250, сульфатів в 3,5 рази більше. Брали воду з річки Комишуваха, побачили, що рівень сульфатів перевищено в 8 разів, концентрація марганцю в 70 разів перевищує норму. Крім цього, брали зразки ґрунтів, там, де були обстріли, де інтенсивні у 2014-2015 році території, які інтенсивно обстрілювалися, де там досі сотні воронок, то ґрунти дуже сильно забруднені важкими металами саме. Наприклад, є присутність титану, якого за нормальних умов взагалі в ґрунті не повинно бути, і дуже багато фактів про те, що після таких обстрілів земля перестає родити на великій території. Люди говорили, що городина в них перестала родити, що абрикоса обсипалась і більше не давала врожаю. Власне, розділяючи вплив війни, прямий і непрямий, то прямий вплив війни на довкілля негативний – це обстріли, які спричиняють забруднення ґрунтів, про які я сказав, це обстріли території критичної інфраструктури, як це було з обстрілом Донецької фільтрувальної станції, з обстрілом Авдіївського коксохімічного заводу і дуже ще багатьох підприємств. Так само було обстріляне підприємство Бахмутського аграрного союзу, яке розводить свиней, і були влучання як на територію самого підприємства, так і в відстійник залишків решток продуктів життєдіяльності. І невідомо, чи пошкоджено герметичне дно зараз, чи потрапляють ці шкідливі речовини в воду. Так само розміщення об'єктів, військових об'єктів поблизу таких критичних об'єктів, пошкодження яких може завдати шкоду довкіллю. Так само ми фіксували, наприклад, на станції Майорська біля і на території очисних споруд стояли українські військові, ми знайшли сліди їх присутності. І природно, що супротивна сторона намагалася їх обстріляти і вибити з тих позицій. В результаті очисні споруди були пошкоджені, зараз не функціонують, і всі нечистоти, які продукують жителі станції Майорська села Зайцеве, виливаються просто в поле, ми це зафіксували. Те ж саме можна сказати про розташування українських позицій на каналі Дніпро-Донбас, який постачає питну воду на велику дуже територію, яка і контролюється зараз урядом України, так і не підконтрольно. І так само внаслідок обстрілів сепаратистів були влучання, які пробивали дуже величезні дірки в цих трубах, по яких подається питна вода. Нам свідки говорили, що така була дірка, що може туди людина пролізти. Особливу небезпеку становлять так само відкрита частина аміакопроводу, який йде з Горлівського заводу з виробництва аміака в Одесу. Є якраз наземна частина перетинає лінію розмежування, і розміщення воєнних об'єктів там теж ми фіксували, а будь-яке влучання, будь-яке навіть мінімальне пошкодження цієї труби може призвести до дуже серйозної значної шкоди довкілля. Отже, є дуже багато цих прямих наслідків негативних для довкілля. Це і замінування територій, це перетворення заповідних територій на полігони, це знищення птахів, як ми фіксували в Приазовському заповіднику з боку представників сепаратистських республік. Дуже багато цінних і навіть червонокнижних представників було фактично знищено, зведено на нівець, в тому числі через те, що там відбуваються не лише військові дії, але й маневри, і навчання. Це все, що пряма шкода, опосередкована шкода, яка призводить до закриття шахт, припинення роботи інфраструктури, зупинення насосів, вирізання підприємств на металобрухт, в результаті чого неналежним чином обслуговуються ці об'єкти, виходять на поверхню ґрунтові води, виходять на поверхню шахтні гази, вони накопичуються в будинках людей, перестали працювати газотехнічні служби, які мусять ходити і обстежувати. Не допускаються на території непідконтрольні уряду України спеціалісти того ж МАГАТЕ, вони не можуть потрапити на шахту Юнком, де був підземний вибух. І в нас є дані про те, що цей об'єкт кліваж, який утворився в результаті, вже затоплено і фіксують вже значне перевищення рівня радіації в ґрунтових водах на відстані 5 кілометрів від цієї шахти. От, власне кажучи, ці всі факти були зібрані, проаналізовані і зафіксовані в цьому звіті. Проте, знову ж таки, переходячи до висновків, можу сказати, що якщо орієнтуватися на статтю 8 Римського статуту, то лише три інциденти можна назвати класично воєнним злочином.
Roman, I really apologize for interrupting you, but we have problems with time, I think. If I may, you have 1 more minute, not more, unfortunately, but can you please comment just briefly on very important question? Do you find that the proceedings of Ukrainian law enforcement regarding those facts that were listed by you is somehow effective and efficient, or they're not, if you have this information?
Дякую. Окей, 1 хвилина. Отже, відповідно до Римського статуту, лише 3 інциденти можна назвати воєнним злочином. Обстріл Авдіївського коксохімічного заводу, обстріл Лисичанського нафтопереробного заводу і підпал сухостою минулого року в Луганській області. Всі інші не можна назвати. Проте, якщо брати про конвенцію НМОД і статтю 438 Кримінального кодексу України, яка криміналізує воєнні злочини, то тут ми особисто бачимо велике поле для співпраці і для застосування прокуратурою, в тому числі, в першу чергу, War Crimes Unit Української прокуратури, тому що ця конвенція забороняє цю широку, довготривалу і значну шкоду довкіллю, і вона дає визначення. Було питання якраз від прокурорів, як визначити. Там, на жаль, немає часу, але зазначено, що широка шкода – це така, яка зачіпає кілька сотень квадратних кілометрів, довгострокова період, що приблизно дорівнює сезону аграрному, тобто 3 місяці. Серйозність передбачає значну шкоду для людського життя, природних і економічних ресурсів та інших активів. І от, якщо говорити про застосування статті 438, відсилаючи до конвенції НМОД, тоді можна за статтею, не екоцида, стаття 438 воєнний злочин проти довкілля, розглядати такі дії, як розміщення вогневих точок та позицій Збройних сил, ДНР або ЛНР, або так само українських, поблизу об'єктів критичної інфраструктури, наприклад, на території Лисичанського нафтопереробного заводу в липні 2014 року, наприклад, насосна станція під селищем Шуми, буквально 2 місяці тому було затоплення шахт, так само як наслідок забруднення водойм та рік, засолення ґрунтів, хімічне забруднення довкілля, заборона доступу спеціалістів на шахти, наприклад, шахту Юнко. Це все може цілком утворювати склад воєнного злочину згідно з українським законодавством. Дякую.
Спасибі велике, Романе. І в мене до вас зараз запитання, але це запитання, яке поєднує насправді меседжі від всіх 3 спікерів. Різвана дуже часто говорить, що порушення проти довкілля, вони пов'язані з порушеннями проти культурної спадщини. Пан Андрій говорив про те, що Україна мало що робила з точки зору своєї полісі з питань довкілля, хоча пріоритети громадян багато в чому співпадають з пріоритетами щодо захисту навколишнього природного середовища з громадян країн-членів ЄС. У мене запитання до вас по вашій документаційній роботі. Які прогалини ви бачили в регулюванні і в політиці України до 2014 року, які, можливо, допомогли б зараз мати менший негативний вплив на навколишнє середовище? Так само, як з порушеннями проти культурної спадщини, ці прогалини, вони невиконання якихось дій до 2014 року, воно не виправдовує ймовірних порушень України, Росії чи України наразі. Але що ми могли б зробити в 2014 році, чи що нам треба буде як державі, як суспільству робити уже коли буде встановлений мир, щоб далі, не дай Бог, якщо знову ситуація конфлікту, регулювання, пом'якшення впливу на навколишнє середовище збройного конфлікту було б легше?
Дякую, Катю, за ваше запитання. Насправді, до 2014 року країна була, щодо дуже великої кількості таких речей, все було добре, налагоджено, працювали сервіси, служби, було передбачені форс-мажори, аварійні відключення, і так як Донбаський регіон дуже сильно населений, дуже там насичений підприємствами, то в тому числі і захист від техногенних аварій, які призвели до широкої шкоди довкіллю, був на високому рівні. Як я говорив, були газотехнічні служби, які регулярно ходили по будинках людей, просто перевіряли там загазованість, чи не виходить метан. Були люди, які обслуговували насоси, підключали там силові кабелі. Були люди, які слідкували за забрудненням шахт, як там в Горлі, це та ж сама шахта, яка виробляє хімпром, і куди там акуратно тоді зливалися. Війна перевернула все з ніг на голову, і потрібні зараз зовсім нові інструменти. Потрібно налаштувати якусь державну єдину систему моніторингу за станом довкілля, навіть включаючи те, що українські чиновники не мають доступу на окуповані території Східної України, проте звідти дані також поступають. Тобто зараз немає якоїсь єдиної системи, і ні країна не знає, що насправді відбувається. Там є якісь звіти, як наш, як інших організацій, які розрізнені, проте немає єдиної системи. Ми певною мірою сподіваємось на цей національний центр документування. Там передбачається так само функція об'єднання, в тому числі і цієї екологічної складової.
А ви могли б коротко просто сказати для тих членів аудиторії, що це за національний центр документування?
Національний центр документування – це ідея створення уніфікованої бази даних всього, що трапилося внаслідок збройної агресії Російської Федерації. Це не лише злочини, це не лише порушення прав людини, це всі події, які потребують реагування і які потребують, можливо, там позовів до Росії щодо відшкодування. Передбачається, що дуже багато державних органів будуть брати участь в наповненні і в оперуванні цією базою, і прокурори, і слідчі поліції, прокуратури, і Міністерство юстиції, Міністерство охорони здоров'я, і Міністерство охорони довкілля в тому числі. І це буде один інструмент, куди можна буде як збирати оці розрізнені реєстри або якісь таблиці просто в Excel хтось веде, або хтось пише в зошиті. Цю інформацію зібрати в єдину базу, яка куди матимуть доступ відповідні служби і службовці для того, щоб розуміти, що відбувається глобально, в тому числі з усіх компонентів. Скільки людей більше хворіє, скільки там колодязів пересохло, скільки будинків було зруйновано, і в тому числі скільки шкоди довкіллю було завдано внаслідок цієї агресії.
Дуже дякую, пане Романе. Марія,
дякую. Мене насправді ми вже можемо українською говорити, бо наші міжнародні колеги вже змушені були залишити нас. У мене ще одне, можливо, на завершення запитання до пана Андрія, якщо він ще тут і готовий прокоментувати. У мене, власне кажучи, питання щодо робоча група, про яку представляє пані Хасан. Вона налічує 12, як ми знаємо, експертів з усього світу. І, власне, мені здається, що також в Україні є доволі свій, можливо, унікальний все ж таки досвід у зв'язку зі збройним конфліктом щодо екологічної шкоди, яка спричинена цим збройним конфліктом. І чи бачите, як ви бачите роль взагалі українських експертів з питань правових і екологів, так, у розробці все ж таки міжнародної системи якогось правового реагування на екологічну шкоду? Тому що мені так видається, знову ж таки, як не фахівчині, що зараз ця система тільки виникає, народжується і удосконалюється. Чи ви бачите, що може Україна привнести в ці міжнародні дискусії? Або, можливо, вона вже це робить?
Дякую. Дивіться, коротко. Спочатку один коментар. З приводу збору інформації про стан довкілля на окупованих територіях. В першу чергу треба почати збирати інформацію про стан довкілля в Україні. Бо вона практично відсутня. Наприклад, по повітрю у нас працюючих станцій, під словом станція маю на увазі плюс-мінус сучасне обладнання. Да? Їх на всю Україну скільки? 3? 4? А скільки треба? 200? 300? Ми говоримо про те, що ми не знаємо, що тут робиться. Тобто в цих умовах планувати якісь особливі надскладні завдання по східним територіям надзвичайно складно, на мою думку. І це, повторюю, питання не тільки того, що уряд поганий. Навпаки, я вважаю, що 2014 року в нас набагато більше уваги приділяється екологічній політиці порівняно до 2014 року. Це такий короткий коментар. Щодо того, що Україна може привнести. Я думаю, що Україна буде, якщо і привнесе, то буде прагматичний підхід. Тому що цей досвід, який ми маємо, він, повторюю, ті питання, які я сьогодні піднімав, екоцид, як міжнародний злочин, може працювати в обидва боки. Тому, звичайно, що наш уряд буде обережно ставитися і враховувати, якщо б якийсь внесок мав би робитися, обережно враховувати будь-які наслідки, скажімо так, такої участі, тому що це політичний процес. Ми говоримо про розробку поправки до міжнародного договору. Завжди буде, тут завжди буде політика на першому місці, я скажу так, а право буде на другому місці. Хоча результатом буде правова норма. Я маю на увазі, якщо ми говоримо про поправку конкретно до статуту Міжнародного суду, кримінального суду. Тому я думаю, що Україна щось привнести може, але щоб наші експерти, там академічна спільнота чи ще хтось це привнесли, має бути конкретна, визначена, стратегічна, політичне завдання. Яка наша позиція і що ми з цього хочемо отримати? Без цього це внесок буде виключно такий, як правильно вам сказати, індивідуально-експертний, да? А не внесок України. Це треба відрізняти. А яким би міг би бути цей внесок, мені, повторюю, зараз складно сказати, тому що я такої позиції не бачу. Я її не бачу, тобто, дивіться, є закон, наприклад, про тимчасово окуповані території, я коротко називаю, да? Там є про культурну спадщину, і є про права людини, і є про соціально-економічну політику, є про довкілля, нема. Ви там жодного слова не знайдете про екологію, довкілля, середовище, нічого. Тобто починати треба з того, що треба вбудовувати єдину стратегію бачення того, щоб дійти до конкретної позиції з питання злочину поправки щодо Римського статуту. Це має все бути частиною єдиного бачення, розумієте, да, стратегії. А довкілля нас чомусь завжди так приписують, але з моєї точки зору воно випадає. Тому, моя думка, без активної, обґрунтованої, виваженої участі і позиції держави внесок наших експертів буде носити, якщо він не буде носити такий індивідуалістичний, я би сказав так, характер, а не державницький.
Пане Андрію, спасибі велике, і мені здається, це такий загальний меседж від всіх наших трьох спікерів, що ми маємо бути реалістичні щодо співвідношення права і політики, і що особливо в питаннях довкілля дуже важлива думка і участь громадськості. І, чесно кажучи, мене збентежила статистика, яку навів пан Андрій, щодо зацікавленості молоді в цих питаннях, тому що в питаннях екоциду якраз, наприклад, професор Філіп Санс, член комісії з визначення, він якраз говорить, що він бачить велику перспективу в цьому напрямі, в напрямі криміналізації екоциду саме через високу залученість молоді. Я дуже сподіваюся, що в контексті України ми також зможемо актуалізувати державну політику за рахунок більшої залученості молоді і пересічних громадян. Марічко, вам слово для завершення.
Дякую. Я хочу подякувати панові Андрію, пані Хасан, ми подякуємо вже окремо. Дуже дякую тим колегам, які сьогодні приєдналися. І ще раз спасибі за ті всі коментарі і запитання. Вони мене переконали в тому, що нам потрібно, можливо, більше взаємодіяти також із середовищем екологів, тому що, власне кажучи, дуже багато інформації, додаткових фактів, які, мені здається, треба включати в розмову суто правозахисну або правову, і дуже дякую вам за це. Я думаю, що також це не остання, мабуть, наша розмова. Хочу також зауважити на тому, про що говорив вже пан Андрій, але, можливо, дещо сфокусованіше, що справді екологічна проблематика окремо звучить в рамках Кримської платформи. Існує окрема робоча група в рамках експертної мережі Кримської платформи, яка зараз засновується, і яка, будемо сподіватися, пропонуватиме якісь і полісі рішення, якусь експертизу саме щодо Криму, попри те, що немає доступу до території, але все ж таки ми будемо стежити за тим, як ця тема звучатиме на саміті, який відбудеться вже 23 серпня в Києві, установчий саміт Кримської платформи. Хочу всім колегам подякувати, ми будемо аналізувати всі ті речі, які були сьогодні сказані, і спробуємо якось це все далі розвивати. І також хочу подякувати, звісно ж, тим, хто нам допомагає організовувати серію International International Law Talks, це Українська Гельсінська спілка з прав людини, це наша організація Медійна ініціатива за права людини і програма USAID права людини в дії. Спасибі вам величезне. Ну і вже у вересні ми продовжимо нашу серію вебінарів наступними вебінарами. Ми окремо анонсуємо тем дуже багато цікавих, так, і будемо поки що триматимемо інтригу, але ми, як і в попередні наші випуски або попередні вебінари, ми намагаємося залучити до розмови ключових міжнародних експертів з тих чи інших питань. Але якщо у вас є запити на конкретні теми, будь ласка, ви завжди можете нам писати напряму Катерині Бусол, мені у Фейсбук, також Гельсінській спілці, медійній ініціативі. Тобто адрес вистачає, чекатимемо на ваші запити і пропозиції. Для нас це було б дуже важливо, тим більше, що в нас така аудиторія спеціалізована, фахова, і спасибі вам величезне. І до нових зустрічей.